In times of war and uncertainty, there is a special breed of dedicated professionals, the United States Army's infantry, ready to answer our nation's call. Common Americans with an uncommon desire to succeed. Forged by adversity, they stand ready to serve their country, the American people, and protect our way of life. America has many of these quiet heroes, many of whom risk their lives in the service of our country. These brave men and women are some of the best trained and best equipped professionals protecting America with deadly force if necessary. Many of these elite combat trained soldiers served multiple tours in combat zones like Iraq and Afghanistan. They use words like honor, code, and loyalty. They use these words as the backbone of a life spent defending something, and they live up to their words. They walk their talk. U.S. Army Iraq veteran Sergeant Jacob Matthew Cadriel was one of these brave soldiers. He was a highly decorated Army veteran who served in 2 tours of duty in Iraq and Afghanistan. After 5 years of service, Jacob completed his tour of duty, came home to Texas to marry his high school sweetheart Erika in 2006 and start a family. Jacob enjoyed being a father and spending time with his family. His son, Jacob Jr., was one of a kind, and they all live life to the fullest. But on April 1st, 2005, Jacob Cottrell was murdered at work by a co-worker, Stephen Young, who shot him in the back. Jacob Cottrell was only 28 years old. Jacob's killer was Stephen Young, who was subsequently convicted and sentenced to 45 years in prison. They worked for a fabrication shop managed by Woven Metal Products, which also owned the premises where they worked. Woven Metal Products was held legally responsible in a subsequent civil lawsuit for $1 million for failing to do a background check on Stephen Young, which would have revealed previous violent criminal charges and convictions that put all their employees at risk. In fact, Woven had never trained any of their workforce in how to address any issues associated with workplace violence. In this insider-exclusive network TV special, Justice in America, Jacob Matthew Cadriel's Story, we visit with Brent Coon, founder and CEO of the Brent Coon Associates law firm, and his co-counsel, Robert Schwartz, who both successfully represented Jacob's widow, Erika. Brent and Bob have earned reputations as unyielding trial lawyers who repeatedly represent individuals and families against big companies and the Goliaths of the world, and repeatedly win. Erika Cadriel was quoted as saying after the verdict, "I will always miss my husband. He was a great father, son, brother, husband, leader, and a great servant to our country. And for the 5 years of his life, he committed to the international war on terror and to keep this country safe." This verdict validates his existence, but will never replace him in our hearts. This is the Insider Exclusive, live from Houston, Texas. It is my great pleasure to introduce Bob Schwartz and Brent Coon to the show. Welcome to the show, guys.
Thanks, Dave. Good to be here.
Today we're here talking about a specific case, Erika Cadriel.
Yes, sir.
And you represented her and her family. But before we get into the case, let's talk a little bit about your law firm. You primarily represent the little guys, don't you, Brent?
Almost exclusively, yes, sir.
Why is that?
I grew up a little guy. My dad worked in one of the local unions, electrician, and most of my friends, people we related with and identified with, were the guys that worked in the plants and the worker side of the class system. And so I related with them growing up. And when I became a lawyer, I had the opportunity to go back in and work in the field where we're somewhat of a protector of their safety and health interests.
Yeah, it is a tougher road to travel, though, isn't it?
It's a much tougher road for a lot of reasons. One is you have to be an independent businessman, and you're not really trained as a lawyer how to be an independent businessman, to run an office, do the business responsibilities, grow your business, finance it properly, staff it properly, fund it properly, and then still do the work that we do, because most of these clients can't afford a lawyer. They lose their wage earner, the breadwinner, when they're killed on the job. They don't have any money. So we not only have to support our firms and our offices, we have to carry the cost of the litigation until the case is resolved so that we can get paid. So,
Right. So
unique burdens.
Right. When you look at these cases, you have to choose them very selectively because you're going to be in the case for maybe what, about a year? How long were you in this case?
This was about a 2-year case.
2 years.
And that's typical, and unfortunately, many times it's longer than that. And we're in it for the long haul. And as you say, if we don't get a recovery for any reason, picking a bad case, maybe the law goes bad, maybe something else happens, maybe the defendant files bankruptcy for unrelated reasons, whatever, we're left out in cold as well as our client.
Right. You bring up a very interesting point. Maybe the law goes bad while you're trying a case,
Sure.
and I've seen this with some class actions.
Many times.
The law changes. And then all of a sudden, I saw someone get a verdict of $200 and some odd million, almost $300 million against the AT&T case. Remember that?
Yes.
And then it was reversed, and they ended up with nothing. So you never know what might change, right?
Well, a perfect example is that we represented thousands of workers that were occupationally exposed to asbestos in Texas, and we did that for many years, over 20 years. And in the middle of all that litigation over those years, the legislature and our judiciary just changed the law and said that if you have an asbestos-related disease, you can't file a lawsuit. And for those people that had already filed their lawsuit, it applied retroactively, and all their cases were summarily dismissed.
Right. And that's our judicial system.
It is our judiciary and sometimes our legislature. Yes, sir.
Let's talk about this case. Why don't you tell us, Bob, a little bit about Erika's husband, Jacob?
Jacob was a pretty incredible young man. He had enlisted in the Army and had been sent over to Iraq, served 3 tours in Iraq, was a decorated veteran when he was discharged, and came back to fulfill their dream together of raising a family.
He married his high school sweetheart,
He did.
Erika, and they had a son, Jacob Jr., correct? And what happened? He went to work like any other normal person would do, right? Got a good job.
He got a job in this metal fabricating plant, and he knew a cousin that was working there and worked there steadily up until this happened. It wasn't very long. It was, I think, about 6 months.
And tell our audience a little bit of what happened that day.
Jacob came to work that morning, and Jacob knew about the event that occurred the night before. The night before, the assailant, or the guy that shot him, had actually created a disturbance and wanted to fight another employee.
His name was Stephen Young, correct?
And Stephen Young was known by the other employees and even the management to have some psychological issues. They actually had him working off by himself. No one wanted to work with him. And he made a comment, or a comment was made to him, and he blew up at another worker and wanted to meet the guy out in the parking lot the shift before. That guy wouldn't go out to the parking lot, and he didn't even show up the next day. But a supervisor was there when all this happened, and the supervisor is the one that stopped it. The supervisor made a decision not to contact his supervisor, but made a decision that he would just talk about it in the morning. And in the morning, he and the man that was going to help him make this decision about what to do about Stephen Young, they were doing that when Stephen Young appeared. But they were not going to let him on the premises. They were going to stop him before he got into the premises. They didn't do that. They were actually in a meeting talking about what to do, even though it already decided that he was too dangerous and they weren't going to let him come back. Well, Jacob was walking through the shop, and Stephen Young was driving a forklift, and they had words. Stephen Young got off the forklift. They were literally face to face, nose to nose. And next thing you know, Stephen Young hits Jacob and knocks him down and jumps on top of him and starts hitting him more. And the other workers rush in to pull Stephen off of Jacob. They separate the two of them, and for whatever reason, only known to Stephen Young, when he backed away, he pulled a pistol out of his waistband and shot Jacob in the left side.
Right, and he died on the way to the hospital, I
He
think.
was actually coherent and talked to Erika. Somebody called and told her, that he had been shot and that he was doing okay. Yeah. And that was the last she heard.
And I think you mentioned before, the office called his wife, Erika, and said that her husband had been shot, correct?
Sure.
And she thought it was what, an April Fool's?
It was actually April 1, so I mean, she found it was just shocking. She couldn't believe it, and she really just thought it was a bad, poorly phrased April Fool's joke.
Yeah.
So it was really difficult for her to even for the gravity of that situation to soak in.
Right. And he was only, what, 28 years old, correct?
Yeah.
I think it was 28. How did the case come to you?
We're very well known in this industry. Most of the work that we handle is that type of it's not necessarily shooting on the job site, but it's occupational fatalities. So the branding of the firm specializing in the heavy industry sector and people getting killed on the job was something that family members of the family knew and suggested they call us.
When you first saw the case, when you first evaluated it, what were the issues that you saw were challenges in pursuing this case?
Good question, Steve. The problems with any of these cases, there are multiple problems. Problem number one is that if one person shoots another person on a job or anywhere else, the first instinct is to blame the person that shot them. They're the one that did it. The employer, the premises owner, they didn't shoot the person. This other person did. The route is, while they may have accountability for it, they're not going to be able to pay the family. Usually those persons are judgment proof, don't have any money, and are not in a financial position for the family to get any kind of restitution. So you look for the bigger picture, which is, okay, this person shot somebody on the job, but why did they shoot him? Did the company have any reason to provide a heightened level of security? Why are guns on the job site? How's all this happening? So you start looking for the responsibility of the people that are in a better position to manage those situations to make sure it doesn't happen. So we have to look at all of those. And in this case, the other confounding factor was that in Texas, as in most states, if you're employed with an employer that has workers' compensation insurance, under most circumstances, you're prohibited from filing a lawsuit. Something we talked about earlier. You can't always bring a claim just because you've been aggrieved and you're injured, even if the other person's wrong, because they have protection.
Obviously, that's meant to protect the employee.
Well, sure it is. That's the only reason they have comp. Most of them.
And in some states, that's not the case. But in the state of Texas, what do you have to prove over and above that to make sure that they're held liable?
In most circumstances, unfortunately, you cannot. The limited Texas law exception, and it varies state to state, is you have to prove a much higher level of misconduct on the employer called gross negligence with malice. It's very hard to prove that standard. And it also can only be applied in fatality. If someone's injured, not killed, they don't have any way of getting around it. In this case, we were able to use some unique ownership issues of the plant. It turned out that the employer here was operating wearing two hats with two different companies, both of them on the same job site, one of which as the owner of the property and one of which as the owner of the employees or the employer of the employees. So we were able to go after the second component of the premises, which was the hat of the company that actually owned the property. And that way we can make it a premises case and hold them responsible under another theory of law other than employer.
So the company that you went after, actually, was that woven metal?
Yes.
Yeah, because they didn't have workers' comp.
Well, there's workers' comp, but the premises owner was one company. The employer was the other company. And they actually, even though it's the same people own all of it, for whatever reasons internally, they decided to have two workforces out there. And they decided to have the ownership of the company with one workforce and the other one to be independent of ownership of the premises. That basically left the one employer, Woven, exposed to the liability where they're not the official employee under the circumstances with Cadriel. The other company was, and that left the premises owner side of the company, the other hat they wore, it left them exposed for a potential premises claim.
In order to prove your case, and you did go to trial, correct?
Yes, we did.
Okay. In order to prove the case, you had to bring on an expert.
We did.
Tell our audience a little bit about that expert, who it is, what he does. We're going to have him on here in a minute, but who is it, please?
Stephen Milwee is one of the foremost experts in the world in security issues. And we talked to him early on in the case. As we do in all these cases, we try to find someone who is really recognized in that field and their area of specialization. And we have to rely many times on their expertise in guiding us. And in this case, we did find a gentleman who's literally wrote the book on plant and job site security. And he looked at the case and said, do we have a case here? In your opinion, said, you have the worst set of facts I've ever seen. You have a great case on this theory if we can circumvent the workers' comp problem.
It is my great pleasure to introduce Steve Milwee to the show. Welcome to the show, Steve.
Thank you.
Thanks for coming here today.
My pleasure.
I understand you're a leading expert in security at companies. Tell our audience a little bit about what you and your company, what's the name of your company? Security Test?
It's called Secure Test. Okay. We're a 41-year-old company located in Florida, and I provide expert witness testimony all over the country on cases primarily where employers fail to practice a reasonable standard of care as it relates not only to security, but their hiring practices, for instance, negligent hiring, what type of background checks, if any, did they do, and what kind of workplace violence prevention policies and procedures do they have, if they have any, and that they practiced. For instance, in this case, they had no policies, they had no training, they had no practices, and so they left themselves very open and exposed to a problem employee getting into the woodwork, which is exactly what happened when they hired Mr. Young.
Yeah, let me ask you a question, Brent. The law is totally different from mathematics. In mathematics, 2 and 2 is 4.
Yes, sir.
When we talk about didn't meet the standard of reasonable care, that's an arbitrary thing, isn't it?
It's very arbitrary.
So how do you actually tell the jury, try to convince the jury that these are normal procedures like you're instructing companies to do? You should have some sort of security check, when you hire somebody. You should have, and they didn't have this at this company, but you should have some sort of seminar or workshop on a regular basis.
Well, and that's the dilemma as the plaintiff lawyer is that we know generally what the company in this case should do, but we're not the best witness to tell them. We can't testify those things. So the jury is left with their common sense for a lot of these issues. But what really helps you get over the hurdle, because the company says, we did everything we're supposed to do, or we did everything that we were legally required to do. And so you bring in a preeminent expert like Steve says, well, you may not legally have to do these other things, but if you don't, you're breaching a general standard of care. And those are the things that are that are negligent, so to speak. And he can then go in and say, this is what most companies do. This is why they do it. And we need that type of testimony so the jury can really understand the difference between what most other companies do and what this company did, or in this case, did not do.
Yeah. How often should those workshops take place?
At least on an annual basis.
Once a year. Bring everybody in, and what do they instruct?
Well, first you teach them to report
something that might look dangerous.
There's a whole pattern of behaviors that people who engage in violence in the workplace typically have.
Like what?
They make overt threats. They make veiled threats. They say, I'm going to hurt you if you fire me. They have a past history of violence. They talk about violence. What I describe oftentimes is they carry their problems and their past grudges around in 2 cement-filled suitcases every day to work. And they never let them go because they don't have the ability to forgive, much less move on. And so there are published standards in the industry that are accepted nationwide, that are developed by ASIS International and ANSI, which are the 2 premier standard-setting bodies that goes through a tremendous vetting process as to what employers should do.
Right. You obviously are advising companies. They call on you probably, right?
They do.
And they say, how can we improve our situation so we're not sued by lawyers like Brent, right?
Exactly.
Because they're not following the law. So my question to you is, when you're talking about some of these behaviors that, you're instructing people, do you give seminars at the company?
Absolutely.
A lot of people just mouth off. They say, yeah, I don't like that guy. I'm going to get him someday. Is that something that should be reported?
Absolutely.
Okay.
The best predictor of future behavior is past behavior. And any type of threat, whether it's veiled or overt, such as a direct threat, I'm going to kill you, is a direct threat. A conditional threat is I'm going to hit you if you come back at me tomorrow. In this particular case, Mr. Young had actually engaged in violence in the previous shift and went home and was allowed to come back. No employer should reasonably allow someone to come back to the workplace without checking in.
Now, here's a big question. I was thinking about it before we got to the show. You vet somebody, they have no criminal record, okay? They don't say anything, make any overt threats or anything at the workplace. But let's say they go out and they commit a crime that the employer doesn't know about. okay, and they don't go to jail, but let's say it's a violent crime. How often should an employer keep revisiting their employees to make sure that their situation hasn't changed from the day they hired them?
Well, our company, SecureTest, is a national background screening company, and I will tell you the standard that, for instance, the Department of Defense uses with us in vetting contractors and vendors and others who go onto military bases or secure facilities. They have to go through a recheck every 90 days and then an annual background investigation again.
Really, every 90 days, working for the government.
If they're a government contractor or vendor.
What about, what do you know about private companies? They don't do that, do they?
No, they usually don't. It's really not expected of them. Again, when you're talking about DOD, heightened levels of security apply to certain types of jobs. But it's also important to note that in this case, Young had a history, a report history. I think he even admitted on his employment application of an incident that had happened at a prior place. And they just took him for his word and just never did an official background check. Had they done that, they would have realized he lied on his own application about the circumstance involved in that prior incident.
Well, and here was one of the most interesting facts, I think, that you were able to present to the jury very well when I was testifying, and that is, not only did he have a prior history of violence that the employer saw in the application or could have seen more by doing more in a background check, but he had been fired from the job because he brought a gun to work, pulled it out against a coworker, similar to Jacob's.
And the police weren't called.
And he would have shot this coworker had the gun not been knocked from his hand and fell to the floor and someone else grabbed it. He was arrested, and he was convicted here in Texas, in Houston, for aggravated assault with a deadly weapon.
You know, that makes me think that almost every employer should have some sort of security check when they come to work every day, especially in plants, because they have a lot of workers and people might have personal grudges, right?
Well, that brought up another instance. Texas is a gun-toting state.
Yeah. Can you carry your gun to work?
Yeah, you can, unless the company says you cannot. You're allowed to take your gun anywhere in Texas.
On the job? On the job.
On the job. You can take them anywhere you want, unless your company, the premises owner, says, we're not allowing them on here. There are a few exceptions to it, but under most circumstances in Texas, as an open carry state, you can carry your guns, you can show your guns, you don't even have to have a concealed permit anymore. And employers, under most circumstances, should have a prohibition of having guns in the workplace. And in this instance, I recall that there had actually been a shooting that occurred in the parking lot out there before, where somebody drove through, was mad at a boss and shot up some cars in the parking lot. So they had still done nothing as a result of that prior occurrence. And in this case, as I point out, we knew that Young was violent, had engaged in very aggressive altercation just the day before, purportedly had an infatuation with guns, always talked about guns, was believed to have guns on him from time to time, and yet the employer's decision, the premises owner's decision about how to deal with it was so passive. One was, the guy's crazy, and everybody knows he's crazy, and had they done any background on him, they would have realized really how crazy, but they knew he was crazy. He was so crazy, he said, leave him alone, put him over in a corner. He does good work, so we make money off of him, even though he's a hand grenade, but as long as we're making money on him, he's doing his job and he's showing up, we're going to keep him here. And they were just completely oblivious to all these risk factors. And even when he got in the fight the day before, and anybody would say, don't let him back on, we probably got to fire him, but we'll go through the proper channels here and paper it. They still let him come back to work the next day, and he still had, as Steve said, he's got this chip on his shoulder about life is treating him wrong. I'm going to kill somebody today, and he just picked Jacob out as the guy who's going to do it to.
Here was an interesting part in the actual shooting of Jacob. I was asked during the trial, what could he have done to prevent this from happening to him? Oftentimes, in cases, there's a term called comparative negligence. One person may have contributed certain factors that makes them partly negligent, maybe 10%, 5%, or 50%. And that's important on the defense side of the case. And in this particular case, here's the one thing that Jacob could have done to prevent his own murder: not show up for work that day.
That's the only thing.
That's the only thing.
Well, that's what the guy that he got in a fight with the day before.
He texted Ricky, his supervisor, and said, I'm not coming to work today. He's going to kill someone.
Yeah, everybody's seen now the video, on the show, and he got off the forklift. He went over, barely any discussion, and punched him in the face and punched him down.
Yeah.
There was no way, no way to prevent that. Anything else to add on the case?
Well, I think in all cases, you have to appeal to the common sense of an average juror. They're not technical people. They're not experts in security or in the law. And so you have to present a story because they're so used to watching crime shows on TV that their attention span sometimes is very short, and you have to comment and focus them on what is most important, that they would say, if my daughter or my son was working there, I'd want them to do background checks. I'd want them to do risk assessments. And in this case, this company was willfully blind. They chose to not do anything.
Yeah, and putting their head in the sand. Basically, like, we don't want to know.
I want to thank you very much for coming and being on the show. Did a great job.
Thank you very much.
These kind of cases bring up the issue that you just talked about. What is the responsibility of an employer here in Texas to protect workers, and what happens? So why do all new employees have to submit to a background check? Why?
Well, they don't have to.
Okay.
But
why should they?
Right. Well, it should, because one is the employer doesn't want to bring someone in who is going to be a problem child. I mean, they'd be problem children for many different reasons. They could have criminal backgrounds. They could have been involved in prior theft, embezzlement of the company. Right. So the last thing you want to do is bring someone in that environment, put them in charge of handling money at your firm, for instance. So those are first issues. You also want to see if they have any violent propensities that bring up a potential issue of trouble on the job site because the person's a hothead, or maybe they have emotional issues or other things that create a workplace environment that's hazardous to the other employees, and that's what we had in this situation.
Yeah. How do you get around, I think federally, you cannot disqualify a person based on its criminal background from a job. Is that correct?
Well, yes and no. I mean, there's a lot of circumstances where you can make a decision not to hire somebody because of those criminal issues. You can't use there's some forgiveness issues that are involved under the law, but just you're not required to hire someone who has a criminal history. Yeah. So in this case,
but you can't discriminate or eliminate them because they have a criminal history.
Well, not exclusively for that.
So it depends on the background.
It depends on all those. You have to look at it and say, is this something that we have a legitimate reason to be non-discriminatory? In this case, had the company done a competent background check, they would have found out that this guy had a track record of violent propensities. We didn't have psychologists and other people involved in the middle of the case, but it appeared from his record he had some schizophrenic issues and some other serious emotional and mental instability issues. And that would certainly be supported by the very unusual behavior and violent behavior he had demonstrated in other public settings and job sites.
Okay. In cases like this was on videotape. What should a person who's injured do on their company premises to preserve the evidence of what happened?
The first thing that you can do, even before something happens, if you're aware of a hazardous situation on the job site or on the premises, that needs to be reported to management. In this case, in any case where you do get hurt, the first thing is you do need to report it to your managers and supervisors and make sure your coworkers are aware. And if it's something that's a serious injury, the best thing to do is go to an attorney and make sure that they file what's called a temporary restraining order for preservation of all the evidence. Because what we do see many times is there will be a very serious incident. The person ends up being taken to the hospital. They're not in a situation to do anything other than try to get better. And in the meantime, the company starts cleaning up the place, getting rid of inflammatory, damning evidence. And there's nothing you can do about it. So it's very important early on to get a restraining order in play that where the court orders them to leave the premises as is. That then gives us time to bring in experts, look at the place like you would with a police crime scene.
Sure. In these kinds of cases, you don't take a lot of these cases because of the laws in Texas, correct? I mean, you have to get over that hurdle of the workers' comp.
Yeah, you have to get over the hurdle. Many times, unfortunately, we have people hurt on the job where workers' comp is clearly going to be their exclusive remedy, and many times it's not a very good remedy. It has a lot of limitations on what it pays, and there's just nothing else we can do. When there is a homicide as one of those exceptions, certainly we look at those very closely, and a lot of those cases that happen are ones that we handle because we have ways of getting around it. And this one provided the unique circumstances where we had the exception to comp that we looked at, but fortunately for the family, we had the other fact that the ownership out there decided to run the premises under two different company entity names, which created liability for the one that wasn't the true employer.
Being well known in the Houston area and some of the cases that you take on, and you take on huge cases,
Yes.
How do you select your clients?
We really let the client select us. I don't look at we don't look at the clients and judge them like, we want somebody that goes to church 7 days a week versus somebody that has their own personal histories. The thing is, are they and their families victims? And it doesn't really matter what those person's characters are. Obviously, if you go to trial, judges and juries sometimes start looking at those. But under the law, Steve, that doesn't matter. It doesn't matter who you are. If you've been aggrieved, you're entitled to your compensation. And that's our job. Our job is to make sure that those that harm others are held accountable. So we take people from all walks of life, and we don't judge them. It's not our job to judge them. It's our job to judge the people that have aggrieved them, have done the wrong. And these people are the innocent victims in that scenario.
Very good. I want to thank you both for being on the show.
Well, thank you for having us.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.